Hi, this is Alan Gassman, and I am pleased to welcome you to the first part of the three-part series, What You Need to Know About Bankruptcy, a general introduction, definitions, and basic considerations today. I have Al Gomez, who is an excellent bankruptcy lawyer from the Johnson Pope Law Firm in Tampa, and I'm pleased to let you know a little bit about Al. Al has been a partner in the firm a couple or 3 years now. He was formerly with his own separate firm, and before that he was with the Stichter and Rydell firm. He is not only an excellent lawyer, but also a real scholar. He's a fantastic writer. He lectures extensively in the area of bankruptcy law, not only for laymen and general practitioner lawyers, but also for specialist lawyers. He has an AV rating in the Martindale-Hubbell Directory and is one of the Florida's legal elite. So Al, welcome. We really appreciate you being here.
Thank you, Alan. Appreciate it, and thanks for the opportunity. Hope everyone can hear me okay, and if there's any interference or any problems, just let us know, and we'll be sure to try to correct it. Alan, today...
So Al, before we start, I just want to mention for the viewers that on Thursday, September 14th, I'm going to be giving a presentation up in Newport Richey for the Charitable Consortium on dynamic estate planning and asset protection strategies. So anyone who wants to be up that way on September 14th, please join us. And also, we're going to be talking about negotiating the purchase and sale of a business with John McDonald of Hyde Park Capital on a free webinar coming up as well. So please let us know. That's on September 26th. And Jerry Hesh and I are going to be speaking in Sarasota for the Jewish Federation. We're going to be talking about charitable planning techniques, asset protection, and other recent developments. So please join us for that. And don't miss the 43rd Annual Notre Dame Tax Institute, where I'll be talking on, guess what, bankruptcy law for estate planners. But there's also fantastic presentations at this institute, October 26th and 27th in South Bend, Indiana. So take it away, Al.
Thank you, Alan. Appreciate the opportunity, as I mentioned. I was thinking as Hurricane Irma is bearing down on us and after the tragedy in Texas, how important it is to have a working understanding of bankruptcy, both as a practitioner and just as an everyday layperson. The reason for that is typically we see a tremendous spike in bankruptcies after any type of natural disaster, hurricanes, and things of that nature. Pretty obvious what happens is in many cases, people are either underinsured or don't have insurance, for instance, for flood insurance, and financial calamities ensue. And as a result, many folks decide that they have no other choice but to file a bankruptcy. And having a decent working knowledge of how it works, and of course being able to utilize, I think, the services of a competent bankruptcy lawyer would be something that's very useful. So what I'd like to do is go through the different chapters that are typically used in a bankruptcy case. In most cases, you'll have an individual, a corporation, some type of business form. I'm going to kind of touch on both of those. I'm not going to focus just on consumers or focus just on business. I want to give you an overview. So my task today is to give you a general overview of how to work through some of these issues so that you can start thinking about, well, which bankruptcy is the one that's the most suitable for the particular problem that I may have that I'm trying to solve. So let me lead off with, of course, the most practical and typical bankruptcy chapter that you've probably heard of, and that's the Chapter 7. And the Chapter 7, think of it as just a straight liquidation. There is no repayment plan in the Chapter 7 case. The Chapter 7 requires certain debtors to qualify. So the Chapter 7 may very well have a means test. Now that depends. The question of whether there's a means test or whether you can qualify to even file a Chapter 7 is dependent upon whether or not the nature of the debt, the majority of the debt that a debtor comes to the bankruptcy court with, is consumer debt or non-consumer debt. So as an example, if you have a car loan, a home loan, credit cards, those are clearly consumer type debts. Those consumer debts, if they constitute more than 50% of your overall debt pool, would then require you to meet the means test. And the means test is fairly strict. And there's a standard that's used tied to certain IRS qualification standards. And to give you an example, in general, you could have a family of 3 to 4, and you're looking at a threshold of somewhere between $50,000 and $60,000 of income. In other words, if the debtor makes more than $50,000 or $60,000 and doesn't otherwise have some sort of exemption or special category that would take them outside of the means test, this high-income debtor would not, they call it high-income debtor, would not qualify to file a Chapter 7. So that you would eliminate that option. Now, for non-consumer debt, as an example of that would be, let's assume that the debtor is a business owner and has guaranteed a loan to a bank. And then the financial calamity hits, they have to consider filing bankruptcy, and the majority of the debt, more than 50%, is non-consumer, it's business related. In that case, the debtor does not have to qualify, does not need to meet the means test. It's very important. So I wanted to just make sure you understood that distinction between consumer debt and non-consumer debt and the implications and consequences that that has with respect to qualifying to file a Chapter 7 bankruptcy. So back to the Chapter 7 and the mechanics of filing it. The debtor files a document, which is a petition, and that petition filed with the U.S. bankruptcy courts, federal court, and the court, immediately upon filing the Chapter 7, certain things occur. First, a trustee is appointed. That is the Chapter 7 trustee. And think of the Chapter 7 trustee as the court's fiduciary, the court's representative that will make sure the debtor is complying with the bankruptcy code, and then ultimately will work through the liquidation process of the Chapter 7. The other thing that automatically occurs upon the filing of the bankruptcy is the automatic stay. The automatic stay is a foundational principle in bankruptcy. The automatic stay essentially says that lawsuits, for instance, cannot continue to be prosecuted against the debtor. So if the debtor was being sued by a credit card company or by a bank for a default relating to a loan, the automatic stay would, at least temporarily, stop the litigation in its tracks. Immediately upon filing the bankruptcy, there's no requirement to provide notice. It simply happens as a matter of law. Operation, it just matters, it pops up automatically. That's an important thing to remember. So in other words, if you are now a creditor and you learn, even if it's some type of rumor, that a debtor has filed bankruptcy, you should investigate it because you're at your peril if you violate the automatic stay. Now, there's obviously exceptions to the automatic stay. For instance, criminal prosecutions. Those are not stayed. There's certain other government police power actions that are not stayed by the automatic stay. There's certain administrative procedures, licensure type suspensions that are not stayed by the automatic stay. So there's a laundry list, and it's found in Section 362 of the Bankruptcy Code. That's where the automatic stay resides, in the Bankruptcy Code itself. The other key aspect of the Chapter 7, it's very important, I think, helps illustrate the concept of the Chapter 7 is the fact that when a debtor files a Chapter 7, it's similar to a snapshot. Think of a financial snapshot where the debtor has essentially laid out his or her financial status on the date of filing. So if you have a September 15th bankruptcy filing, that's your snapshot. That's the petition date. And that date has significant meaning. Consequences flow from that date. For instance, in bankruptcy parlance, the events that occur after filing the Chapter 7 are known as the post-petition events. If it's pre-petition, pre-filing of the petition, then the pre-petition type events also have consequences. Let me give you an example. Let's assume that prior to filing bankruptcy, me as the debtor purchase a lotto ticket, and I'm holding in my hand the lotto ticket, and I win. The next day, I file a Chapter 7 bankruptcy. The trustee, since it's a pre-petition asset, the trustee would be entitled to the money, to the lotto ticket winnings. On the other hand, if the purchase occurred after the filing of the Chapter 7, post-snapshot, the lotto money belongs to the debtor, no matter what the bankruptcy trustee thinks. So that's just one, I think, easy way to illustrate the significance of post-petition and pre-petition. I will tell you, just for purposes of trying to explain the post-petition aspect, and one of the exceptions that comes up frequently in Chapter 7, and that is if there is an inheritance within 180 days, 6 months, from the filing of the Chapter 7, those funds belong to the trustee. So very critical. That is an exception to the post-petition type of claim that I was talking about earlier. Okay, so we've talked about the snapshot, we've talked about the automatic stay, we've talked about the trustee. I've mentioned to you that there's a petition and that the snapshot is somewhat like the debtor's financial picture. Well, that financial picture is illustrated by the debtor's schedules, bankruptcy schedules, and a document called the Statement of Financial Affairs. These are all generally together, and it's 40 or 50 pages of detailed financial disclosures. One section, for instance, has Schedule A, real property, Schedule B, personal property, Schedule C, your claimed exemptions, Schedule D, secured creditors, Schedule E, priority creditors, etc. So there's a series of disclosures all meant to provide basic financial information and detailed information concerning the debtor in the filing of the Chapter 7. The Statement of Financial Affairs gets more detailed from the standpoint of asking questions. For instance, did you sell any asset within the last 2 years? All of those questions are significant because if the debtor lies on the schedules, not only can that be a criminal offense if it's proven that the debtor intentionally committed a criminal act, but it also has consequences in the bankruptcy, and I'll get to this later. It may cost the debtor his or her discharge, which is the whole reason why they wanted to file bankruptcy in the first place, is to eliminate their legal responsibility to pay a particular claim. So in any event, you have the filing of the detailed financial forms, schedules, and the Statement of Financial Affairs. And what does the trustee do with that document? Well, the besides just basically reviewing it, the trustee is going to focus primarily on Schedule C. And Schedule C, in the case of an individual debtor, is very significant. Schedule C provides all of the debtor's claimed exemptions. Now, the exemptions, as many of you know, in Florida are very generous, as an example. There's an unlimited homestead exemption, for the most part. We have an exemption relating to annuities, cash surrender value of life insurance policies, IRAs, 401ks, retirement type, tax qualified retirement type vehicles are all exempt, the 403Bs, etc. We also have other exemptions that are federally mandated, some veteran benefits, for instance, and things of that nature. We have other type of exemptions that may not be as significant in the Chapter 7, but do pop up, and you should be aware of it. Florida has codified the exemptions in Chapter 222. They're also found, especially the homestead exemption, in the the state constitution, which is Article 10, Section 4. In any event, other exemptions that kick in that play in an individual Chapter 7 case that is of significance would be the personal property exemption. And here you have a very low threshold depending on whether or not you have a homestead, whether you've claimed the homestead or not. If you claim the homestead, then a debtor can claim an additional exemption. Typically, the exemption for personal property is only $1,000 per debtor. And then when you have the homestead, it's limited. Your personal property is limited to $1,000. However, when you have, for instance, a rental property and you don't have access to a homestead, you're not claiming the homestead, then there's the possibility of getting a larger exemption, approximately $4,000 plus a possible wild card, which is typically used, so it's $5,000. So those are the type of assets that the trustee is going to focus on. Now, why does the trustee do that? When you think of the exemptions, think of basically the trustee setting up two buckets or two categories of assets. For exempt, the debtor keeps all the exempt. For non-exempt, the trustee is able to liquidate those. So, for instance, if there is a piece of real property, it's not homestead protected, and it has some equity, the trustee is going to be able to liquidate that and then use those funds to pay creditors from this bankruptcy estate. The exemptions require that a party in interest, either the trustee or a creditor, file a timely objection to the exemptions. So the debtor claims the exemptions, and then there's certain time frames that kick in, and I want to go through that real quickly. Think of Chapter 7 as having 30-day increments of time. The 30-day increment, if you file the petition and that's your snapshot, approximately 30 days later, you can count on the court setting a 341 meeting of creditors, typically when it's held. And a 341 meeting of creditors is simply the meeting that the debtor will attend with a lawyer if they have an attorney, and the trustee will be there. Other creditors have the right to be there and ask questions if they choose to do that. And the 341 meeting generally lasts between 5 to 20 minutes, and the trustee asks questions typically tied to the schedules and statement of financial affairs. "30 days after the meeting of creditor and the conclusion of the meeting of creditors, that is the deadline to object to your exemptions, to a debtor's exemptions. If there's no objection to the exemption, the debtor keeps it. Or if the objection is not broad enough to include a particular basis, that could be a basis for the debtor to keep the exemption. or the asset is exempt, I should say. So now we have, just going down the timeline, we have the filing of the case, it's just a snapshot. 30 days later, we have a meeting of creditors. 30 days after that, we have the deadline to object to exemptions. And then 30 days after that period of time, basically 90 days after the snapshot, is a very important deadline. That's the deadline to object to the debtor's discharge or to file what we call a complaint for dischargeability. Okay, what does that mean? As I mentioned before, the debtor's primary goal in the Chapter 7 case is to obtain a discharge. Now, just to digress briefly, I had mentioned earlier that you have Chapter 7 being a tool that's used by corporations, businesses, and individuals. Well, an individual is looking for a discharge. That's the court order, basically the determination by the bankruptcy court that certain obligations and debts are wiped out. Now, at Chapter 7 for a corporation, there is no discharge for the corporation. Many people misunderstand that concept and think there's a discharge. There's no discharge. Now, there's still an automatic stay, and there's still issues with respect to the liquidation. But essentially, think of the corporate Chapter 7 as just a way to bury the body. It's the conclusion and the end of the life of that business. And that's typically what the Chapter 7 is used for in the corporate world or the business world. Lights off, no continuation of business. Trustee simply shuts down and closes the business. I will say, just as an aside, I think most small businesses choose not to file the Chapter 7 and instead simply choose to, what we call, die on the vine. And in that case, most creditors either go away or decide that there's just nothing there to pursue. And obviously, there's always exceptions to that, but in many cases, the majority of times I see the situation with a small business just simply letting it die on the vine and not proceeding with a type of bankruptcy, either a Chapter 7 or any other type of insolvency liquidation tool. Okay, so let me go back to the discharge and the objection to the discharge and why that's made and the grounds for doing it in many cases. So let's assume that there is a obligation that's tied to alimony, support, and maintenance. You have an ex-spouse coming into the bankruptcy as a creditor and saying, wait a second, I'm owed money based on a marital settlement agreement, for instance. Well, that's a basis to seek non-dischargeable status in the bankruptcy. In fact, in some cases, there are some types of debt which do not require a timely filing objection to the discharge or complaint to determine dischargeability. For instance, taxes. The IRS is the super creditor. IRS, we call it the super creditor because even exemptions are not protected against the IRS. Any Florida-based exemption is not protected. Any federal type exemption, Social Security, et cetera, not protected. So IRS is super creditor. There are some exceptions to discharging the IRS's income tax, for instance. However, you have to meet some stringent requirements. It requires the filing of a bankruptcy adversary proceeding, which is a special lawsuit within the bankruptcy. And it's fairly complicated. It's got to be generally taxes that are more than 3 years old, and there's a bunch of hoops you have to jump through in order to seek a discharge. So in general, I think you're safe in assuming that taxes or claims held by the IRS are not going to be dischargeable as a matter of law. Alimony, support, and maintenance is the same way. Property settlement agreements are non-dischargeable. That's another fairly recent clarification made in the Bankruptcy Code. Intentional torts. So in other words, you're a debtor, you've been held liable for an intentional tort, such as assault and battery or something of that nature. And in the civil arena, there's a money judgment tied to that intentional tort. The victim would have to file a timely complaint to determine what we call dischargeability. So I've mentioned now an objection to discharge and a complaint to determine dischargeability. What's the distinction? What's the difference? An objection to discharge is where the debtor would have gone through bankruptcy, and because there was some offense that the debtor has committed with respect to the bankruptcy system, that's the easy way to think about it. For instance, the debtor didn't truthfully disclose information on the schedules, and that information was material. For instance, they have the condo and significant equity in a foreign jurisdiction or in another state, and they don't disclose it, and the trustee finds out about it, or another creditor finds out about it. And what I see frequently is the ex-spouse finds out about it, learns about the schedules, and then tells the trustee, and then you have the objection to discharge. So obviously false oath is a grounds. Failure to keep sufficient books and records is a grounds for an objection to discharge. Things that the court and the Bankruptcy Code is determined to be sort of an offense against the system itself, the bankruptcy system. The consequence for having a finding of an objection to discharge is that the debtor's entire ability to get rid of the debt would have gone through, they would have gone through bankruptcy, risked their assets to the trustee by way of whether they're exempt or not, but then been unable to obtain a discharge. The discharge would be blocked, and there possibly can be some criminal implications as well. So it's significant, and it's something that shouldn't be taken lightly, obviously. On the other hand, complaint to determine dischargeability, or a non-dischargeable debt, is a debt that allows a creditor to do some surgery, in essence, and dive right into the case, pull their specific debt out of the case, and determine that that debt is non-dischargeable. So, classic example of that would be, I've gone to a bank, I'm the debtor, I have filled out a financial statement, and I misrepresented my income on the financial statement. And I obtained a loan from the bank. Bank relied on my financial statement, loaned me the money. I turn around shortly thereafter and file a bankruptcy. Bank is going to come in and say, wait a second. We didn't know about this. This is a lie. You did not truthfully disclose your income, for instance. And they can pursue a false financial statement claim, what we call 523 AB, in the bankruptcy case. And if they're successful, they would then be able to exclude that particular debt. So again, the main point there is objection to discharge is the entire discharge is eliminated. No debt is discharged. So you get stuck with all your credit cards, all of the debt that would otherwise be dischargeable, as opposed to the dischargeability, which is a specific type of debt. And you can find that in 523 of the Bankruptcy Code. Another thing to keep in mind that's important I want you to make sure that we cover secured debt and unsecured debt. So secured debt generally appears on Schedule D of a debtor's schedules. And on Schedule D, the debtor will list the collateral, description of the collateral, the value of the collateral, whether the secured creditor is fully secured, undersecured. So, for instance, there's a car, and the car is worth, say, $10,000. There's a car loan, and the car loan is for $15,000. In the case, let's assume Ford Motor Credit is the company that holds the lien and financed the purchase of the car. Ford Motor Credit would have a secured claim up to $10,000 and possibly an unsecured claim for the balance. Now, its significance in listing the secured and unsecured, one of the consequences is that the secured creditor then will typically require the debtor to either surrender the collateral, reaffirm the debt, which means even though the debtor may be entitled to a discharge, they are agreeing that they will be contractually bound to that creditor, and they will reaffirm that obligation post-bankruptcy, post-petition. The third option is to basically redeem it, redeem the asset. That generally is an option that's not very likely. And that's where you would essentially pay cash for the value of the collateral. And most debtors who go through Chapter 7 won't have the cash. You have to have the rich uncle or a family member that can assist in those type of cases, from my experience. Now, so what happens with a secured creditor when there's a discharge? Again, if there's been a reaffirmation, they're covered, the debtor's on the hook, and if the debtor isn't paid, the secured creditor is free to take action and try to either foreclose, and it can even sue the debtor for a deficiency, if there is a deficiency, or can sue him for money judgment. On the other hand, unsecured creditors, credit cards, loans that are guaranteed, things of that nature, those are typically the type of debt that primarily gets, that's the debt that gets discharged. And that's the debt that is eliminated in the Chapter 7, and why people choose to file the Chapter 7 in order to get the benefit of that discharge. Examples that I've had over the years, a developer who tries to continue in business, the market turns, they have substantial guaranteed debt owed to a bank. They guaranteed, for instance, financing of certain projects. The project then goes bust. The individual is guaranteed it, and the bank pursues the individual after foreclosing on the project. That liability could be in the millions of dollars. And in that case, the debtor generally has no other option but to file a Chapter 7. It's non-consumer debt, business debt. So that's a classic example of the filing of a Chapter 7 to eliminate a substantial debt. A couple other topics to discuss in the Chapter 7, and it's very important. The trustee is given certain strong-arm powers, and there's clawbacks, as we call it. Strong-arm powers would be to recover property that was dissipated, sold, or transferred shortly before the bankruptcy filing. So here are some of the time frames to keep in mind. If you have a transfer that occurred that was intentionally fraudulent, and that occurred, say, within 2 years of the filing of the bankruptcy, give an example. I intentionally transferred my vehicle to a family member. I still drive it. I pay the maintenance, but I don't have title to the vehicle. And I claim that this vehicle was transferred and is not my asset. Well, if at the time of the transfer there was a pending lawsuit or there was a claim that was outstanding in default, then that's going to give rise to what we call certain elements, badges of fraud. So in the example I gave you where I transferred the vehicle to a family member, one of these badges of fraud is that the insider received the transfer. My insider, my relative, my business partner, etc. And they received it for little or no consideration. In addition, I am still in control of that asset. Just has all the hallmarks of something that doesn't meet the smell test. The fraudulent transfer is broken down into two different basic categories, but a lot of times they overlap. The trustee files a lawsuit. They generally proceed under both grounds. And that is, the first ground is under actual intent. Now, it's difficult to prove actual intent. If you were simply relying on a debtor, for instance, say, okay, you got me. I did do it intentionally. That very seldom is going to happen. So the court have come up with a workaround, and that's this concept of the badges of fraud, which are indicia of intent, that the courts can consider and weigh and make a determination whether a debtor has intentionally transferred an asset and committed a fraudulent transfer. The other second part of that equation when you're trying to pursue a fraudulent transfer would be a transfer that's constructively fraudulent. Well, what does that mean? Well, by constructively fraudulent, that's the case, for instance, where the vehicle was transferred and it was transferred for a number that was well below what it's really worth. In other words, I sold the car to my family member. The car was worth $10,000, and I sold it to him for $500. It's an extreme example, but it's clear that in that case, the family member did not pay reasonably equivalent value. That's the term of art. There's no reasonably equivalent value paid. So those are two ways the trustee can claw back assets. We call the fraudulent transfer. 548 of the Bankruptcy Code is a 2-year reach back. The trustee also can avail themselves of 544, which allows the trustee to step into the shoes of a state court creditor and utilize Florida statute 726. That has a 4-year statute of limitations, and in the case of concealment, it could be as much as 5-year statute of limitations, or statute of repose, as they call it. In any event, that is one key factor used by the trustees, or one key tool, I should say, used by the trustees to recover assets and bring them back in. The next tool that the trustee uses is a preference. A preferential transfer was a transfer relating generally to a loan. This is the classic case that you see, where, for instance, the debtor knows it's going to file bankruptcy and decides that, well, gosh, I've got to pay my mother-in-law back for the loan or they'll be held to pay. So he or she pays mother-in-law back for the loan made to the family, and that payment would have occurred within 1 year of the filing of the bankruptcy. And this is important. The preferences have set clawback dates, and those dates are 1 year before the filing for insiders, 90 days before the date of filing or the petition date for non-insiders. So in the case of a vendor, if it's a business, for instance, if the debtor business files bankruptcy and repaid a vendor on an invoice that was outstanding for quite some time and just hurried up and paid him because they wanted to be in their good graces, that would be potentially a preferential payment that can be recovered by a trustee. Now, in dealing with preferential transfers, another example of that would be if I run out, I get a judgment, I record the judgment as a creditor against the debtor's property, and then the debtor files within 90 days of me recording the judgment. By recording the judgment, I'm hoping to be a secured creditor, which gives me greater rights. But if the debtor files within 90 days, the trustee is going to eliminate any lien on the collateral. So those are some basic important clawbacks the trustee has. I'll mention, just touch on a couple more. The Bankruptcy Code was amended not too long ago to deal with what they call the homestead loophole, the mansion loophole. And that is, many debtors would move to Florida. They would then acquire or buy a huge mansion or homestead and claim that under Florida's unlimited homestead protection, that they were entitled to keep the home. It worked. So Congress addressed that by adding a couple provisions in the Bankruptcy Code about debtors who move into Florida and don't stay a sufficient period of time. Also, debtors who have engaged in a fraudulent transfer, putting money into their homestead within 10 years. That's a 10-year reach back under 522 paren O in the Bankruptcy Code. 522O allows the trustee to reach back and try to determine if there was a fraudulent transfer into the homestead, and therefore the trustee should be entitled to a lien, for instance, on the home. There's some nuances to that. 522, for instance, if you have a tenancy by the entireties, one spouse files the bankruptcy, but the other spouse does not, and only one spouse is obligated to pay, that could be a bar to the trustee's effort under 522, but I don't want to get too complicated on that. Okay, let me touch on the double-digit bankruptcies. This is the Chapter 13 in the next slide. Chapter 13, similar to Chapter 11 in that in the Chapter 13 or 11, any of the double-digit bankruptcies are repayment plans, essentially. Now, we talked about the snapshot concept in the Chapter 7. This is different. The Chapter 13 and the Chapter 11 are prospective. They look into the future. And in the case of a Chapter 13, if the debtor is able to qualify for the 13, you must be eligible. The eligibility is tied to debt, unsecured debt of less than $383,000 and change, and secured debt of less than about $1.1 million. So what happens if you're over those thresholds and you don't otherwise qualify for a Chapter 7? Then your only option is the Chapter 11. So many times we say that the Chapter 13 is a poor person's Chapter 11. Keep in mind that Chapter 13 cannot be utilized by corporation, LLCs, or business entities. You have to be, for instance, it could be a sole proprietor, but it's ultimately an individual. So keep that in mind. The 13 is a repayment plan. Now, what are some of the main distinctions between a 13 and a 7? I mentioned one, which was it is prospective. You file the Chapter 13 and you're looking into the future. Well, how do you fund this plan? Well, typically, plans are funded, your repayment plan, are funded by net disposable income. And net disposable income is essentially after you've earned your paycheck, you're going to get taxes deducted, FICA, etc., and then whatever's left after paying your living expenses, and that gets scrutinized, it's a whole nother issue, but assuming that they're reasonable, then you're going to hopefully have some money left over. If you were to go through your budget and eliminate the obligations that you're seeking to discharge, such as, let's assume you're paying the credit card company $2,000 to $3,000 per month, every month, and that was what you were trying to dig out of and trying to eliminate. You could basically take that money and put it into your Chapter 13 plan. For the most part, net disposable income is going to require you to put a substantial amount of the net disposable income and contribute it towards the plan in order to get a discharge. And in a Chapter 13 and individual Chapter 11, same concept, you have to pay all of the plan payments. In most cases, it's a 5-year plan. So you got 60 months after the court approves the plan to pay creditors. And the way that the payment mechanism in the Chapter 13 is unique, because in that case, there's a Chapter 13 trustee. Now remember, we talked about Chapter 7 trustee. The Chapter 7 trustee wasn't interested in any payments. He was simply liquidating. That trustee was liquidating assets. On the other hand, in the Chapter 13, the trustee's role is more of a debt consolidator, if you will, and an administrator, that the debtor, writes one check for all of the plan payments. Certain exceptions if you have to pay your mortgage, home mortgage, and things that they're secured claims. But for the most part, you write one check, think of it as a debt consolidation, goes to the Chapter 13 trustee, and the Chapter 13 trustee then writes the smaller baby bankruptcy checks to the creditors based on the percentage of their claim and the net disposable income. So you could have a situation where a debtor is paying 10 cents on the dollar, no interest, over a period of 5 years. It's a possibility. It could be a 20% plan. It could be a 30% plan. Who knows? I mentioned that to get a discharge, the individual debtor has to pay all of the plan payments. So in year 5, the conclusion of the plan, they'll get a discharge. Now, this is the reason why some debtors don't like Chapter 13, because you never know what's going to happen during these 5 years. You can get fired, get divorced, whatever. Life's adversity can come your way, and you may not be able to fund the Chapter 13 plan. Then you're stuck with other options. You might have to convert your case, your Chapter 13, to a Chapter 7 bankruptcy. So when you think of Chapter 13, think of prospective, unlike the snapshot. Think of the 13 as having its qualification for debt. You have to have less than $383,000 in unsecured and less than $1.1 million. You have to also keep in mind that the debtor is going to propose a plan. That plan is going to be tied to net disposable income. And one other key aspect is that a creditor in a Chapter 13 case can, of course, participate, file objections, etc., and say, wait a second, we shouldn't be paying for the private school tuition or the country club membership. That should go to the creditors. Well, in my experience, in most cases, the Chapter 13 trustee does an excellent job in previewing all of those issues, and most practitioners know that there are limitations to what a debtor can technically get away with. So the 13 is an excellent vehicle in certain cases where, for instance, the debtor may be a high-income debtor, doesn't qualify to file a Chapter 7. 13 is their only recourse. Chapter 13 is also excellent for reinstating a mortgage, a home mortgage default. That's when you see it very frequently. During the mortgage crisis, you saw numerous Chapter 13s filed where there was perhaps a hiccup. The debtor lost his or her job. They couldn't pay. They got behind. The bank accelerated the mortgage, filed a foreclosure action, and the Chapter 13, the filing of the 13, just like the Chapter 7, has an automatic stay. But the 13 is unique in that it allows a debtor to cure and reinstate a mortgage. So you can propose a plan, reinstate the mortgage, make payments, catch your breath again, spread things out. Chapter 13 is an excellent vehicle for that. Another thing to keep in mind on Chapter 13 is that, remember we talked about the importance of exemptions in Chapter 7. Well, in Chapter 13, exemptions are important as well, but the trustee and other creditors typically don't focus on the exemptions as much because the debtor in a Chapter 13 holds on and keeps those exempt assets. There is no liquidation of exempt assets. There's no big fight over whether, the personal property is worth $1,000 or $10,000. In that case, what happens is the debtor is basically holding on to all assets, both exempt and non-exempt, all of them, and then trying to propose a plan based on their net disposable income. Now, there's a very important test that determines whether the plan is going to be confirmed or not. The confirmation or the confirmed plan is basically the culmination of the agreement. It's a debtor's plan. If it's confirmed by the court, then that means that creditors are bound by that plan. So the important test to determine whether you're confirmed or not is whether or not the debtor's plan meets the liquidation test. And what that means is if you were to take all of the debtor's non-exempt assets in a Chapter 13 and you came up with a value for those assets, a hypothetical liquidation value. So in the case of, for instance, the personal property, the debtor has $5,000 more personal property that is non-exempt. The debtor may have some other assets that are non-exempt. And if those assets in total are more than what the total plan payments are, then in that case, the debtor would not be able to confirm as her Chapter 13 case. Chapter 13, you don't see the clawbacks as much at all, but they're possibly, they're available. So that's essentially the Chapter 13. I'll briefly go through the Chapter 11. I've touched on it as well. If we can go to the next slide in Chapter 11 context. Okay, so Chapter 11, it's primarily used for business entities. This is the area that I primarily focus on, Chapter 11. Chapter 11, to give you some of the key concepts, we have a petition date, we have post-petition, we know that the filing of the bankruptcy, we're looking at a prospective plan. Chapter 11 is principally a reorganization repayment plan. Now, there are variations off the theme. You can have a bankruptcy sale. So you have basically a Chapter 11 filing, you then have a sale like an auction, and the business is sold, and for the most part, the bankruptcy is over, in that you may be just simply having an administrator, or we call a Chapter 11, a plan administrator, simply collecting some funds and paying it out, consistent with whatever's left and the claims that are filed. Chapter 11 is much more complicated, much more costly. To give you an example, just in general, the range of a Chapter 7 case is anywhere between $1,500 to $5,000 as an attorney fee. The fee for Chapter 13 can be anywhere between $4,000 to $8,000, somewhere in that range. The Chapter 11, on the other hand, there are retainers of $250,000, $200,000, you name it. I think in Tampa area and Florida in general, you're looking at somewhere between $30,000 retainer and $50,000. I think that's fairly average from what I've seen. But again, the main point is it's very expensive, takes a lot of time, it's much more complicated. There are rules that kick in a Chapter 11, such as upon the filing, the debtor is going to be given a period of time to propose a plan. Generally, it's 120 days. And then once that plan is proposed, creditors get a chance to participate and vote for the plan. There's a solicitation process. There's a document that's filed called a disclosure statement, which operates somewhat like a informational piece, a proxy. If you were trying to buy stock, you'd get the proxy, read it. Same thing. So you have the disclosure statement and then the plan. And the plan is the guts of the contract that the debtor hopes will ultimately be confirmed by the court, and then it'll serve as the go-forward reorganization plan that all creditors are bound to. Now, one of the features of a Chapter 11 is that the debtor is in control. The debtor is called a debtor in possession, shorthand DIP. The debtor in possession is basically afforded an opportunity not only to file a plan, but to operate the business. They're expected to operate the business. And what Chapter 11 essentially does is, on the petition date, the pre-petition debt, mainly the unsecured debt, is the debt that's going to be restructured in the bankruptcy case. Now, again, lots of variations, a lot of different nuance, but for the most part, if you have, for instance, I put a Blockbuster, Circuit City, this is probably a little dated, but you have these companies that have gone through Chapter 11, they have significant vendor debt. And this vendor debt can be in the millions of dollars. That debt is then dealt with in the Chapter 11 plan. The debtor is prohibited from paying any kind of unsecured debt until the plan is approved. And that process could take a year or more to get a plan approved. What happens in the interim? In the interim, the debtor is allowed to utilize its funds, what we call cash collateral, in order to pay creditor claims for the ongoing business, the post-petition operation. That's what typically happens. The pre-petition debt is frozen and kind of set aside, and there can't be any payments to the unsecured pre-petition amount, but the post-petition obligations for the everyday ongoing business, payment of the utilities, insurance, payroll, all that, those get paid. Okay, we can go to the next slide. Wanted to touch on a couple other points, and then we'll wrap up. Involuntary bankruptcy. This is important to know, and this becomes a tool for creditors. The involuntary bankruptcy, although not frequently used, has been used very effectively. And in that case, you can have one creditor with a judgment, for instance, and as long as the monetary threshold is met, this is Bankruptcy Code 303, which is approximately $12,000, more or less. I'd have to take a look at it, but that's about what it was. And this one creditor can force a debtor into an involuntary bankruptcy. And that's if there are fewer than 12 total creditors. On the other hand, if there's more than 12 or more creditors, then you need 3 creditors to join in. So again, very powerful. Make sure to keep in mind that, you know, if the liability is contingent or there's a dispute, bona fide dispute as to the liability or amount, that can be a disqualification, and there's significant consequences if an involuntary is filed and it's dismissed because it was improvidently filed. So be on your guard for that. I think that's about all I have. I've covered the fraudulent transfer and preference with you previously, so I think we're good there. Sorry I didn't have any much time to ran up to the limit there, but if anyone has any questions, feel free to send me an email. I'm at al@jpfirm.com, and go on our website as well. al@jpfirm.com, and I'm happy to answer whatever bankruptcy questions you may have. I do that for many attorneys and professionals.
Al, thank you. That was a wonderful, wonderful presentation. Our next presentation will be scheduled, and everyone will be notified soon for part 2. There's going to be part 2 and part 3. And if anyone would like a transcript of this discussion, please let us know. Al, I was going to ask questions at the end, but you answered all my questions. You really do a fantastic job covering the basics and the intermediate here. Thank you very much.
You're welcome. Thank you, Alan.
Okay, everybody, have a great day, and may the rest of your time be billable. And good luck with the hurricane.